I'm Jeff Risch. I'm a partner in Smith Amundsen's Management Side Labor and Employment Group. My partner and colleague is Kelly Hobb-Talich. And Kelly, I don't know if you wanted to say anything. Hello.
Sure. Good afternoon.
Kelly and I have been working with a number of clients of late on recruiting and retaining employees and trying to be creative. And while we have clients and we're collaborating with clients on how to be creative to recruit and retain, we of course need to navigate these waters carefully because there are many legal pitfalls. No good deed goes unpunished. Your benevolence will not be rewarded in this lifetime. You've heard it, you've seen it, and probably many of you have experienced that. We're trying to address this problem, this growing problem and concern of a labor market that is very competitive. And there's just, the reality is that there are a lot of jobs that still need to be filled. And this is hitting certain industries harder than others, but I think it is impacting most employers and most, if not all, industries. But hospitality comes to mind, construction comes to mind, manufacturing comes to mind, warehouse distribution. Quite a number of challenges for many industries, but there are some specific that really come to mind and have been that Kelly and I have both been intimately involved in the last few months. Transportation, another one, healthcare. It seems like it's a growing problem. Kelly, I don't know if you have any opening comments on that.
Yeah, I mean, I've seen it in all across the board. I've seen it with accounting firms, even having trouble recruiting accountants right now. So the squeeze for talent seems to be therapists. I have a client that does therapy and is having trouble as well. So it seems to be across the board. So we'll be talking about techniques that work for a variety of employee populations today, salaried, higher level employees, as well as, hourly employees.
Yeah. So thanks for everybody joining us. And I hope that this will be worth your time. I think it will be. And we'll get to the meat and potatoes of the presentation now. So we all read things, we all see things. This is probably something you've seen or heard over the last few weeks, but I found this article recently. I read it, a recent CNBC online article, I think just last week, and this was the quote that stood out to me. Job placement site Indeed estimated that there were 9.8 million job openings as of July 16th. I digress a little bit. I think that number has actually increased over the last few weeks. The last I saw was well over 10 million now, far more than the 8.7 million considered unemployed. And in a survey, I don't know how reliable the survey is, but in this particular survey, 5,000 job seekers cited health concerns as a reason for not looking for a job. That concern declined, with a growing number citing a lack of need of a job due to a financial cushion as the top response. So the COVID healthcare pandemic is now second to I just don't need a job in light of my financial circumstances at the moment. Now, if you know who this is, you probably have a pretty good sense of humor. If you don't know who this is, you're probably better off for not knowing. But Kent Dorfman, there's a line in Animal House where they're looking at the pledge class, and they show Kent Dorfman, who's a legacy, by the way. His picture shows up on the screen, and somebody shouts, "We need the dues," because he wasn't a popular pledge, apparently. So this whole, Kelly's going to talk about criminal background checks, job references, drug screening and testing in the pre-employment stage. There are things that we would typically do and recommend. It's the old saying, beggars can't be choosers. And I think we all have to realize that there are some Kent Dorfmans out there. No offense to those who love Kent Dorfman, but there are Kent Dorfmans out there that we might not take in and take on, but we are in trying times, and we just need to be mindful that our processes and our practices and our procedures, from a timeliness standpoint, from just being a royal pain in the neck standpoint, to being a detriment to bringing in individuals' bodies, may prevent us and may tie our hands to the point where it's diminished returns. So just keep that in mind. Keep Kent Dorfman in mind as we go through some of this material. So there's some topics to discuss. I think this is the main topics for today. But your Q&A questions, you might have hypotheticals, you may have situations that you want to address, and we might not address those today, but you have the ability to send in your question, send in your concern using the Q&A function on your screen. We'll get to that either today or in the next day or two by email. But remote work, signing and retention bonuses, perfect attendance bonuses, gifts and prize drawings. Kelly's going to talk a lot about deferred compensation, flexible schedules. We'll talk about non-compete agreements, temporary relaxation of background checks. And Kelly, you're going to be covering that mostly, drug and alcohol policies, and then other employee benefit programs that are near and dear and we should discuss in the next hour. So remote work, starting with remote work, this is something that a lot of employees are looking for. I want to work from home. I want to work wherever I feel like it. I want that flexibility. I got some of that freedom. I got the taste of some freedom in the last year and a half, and I want that to continue for a variety of reasons. And so we employers, you need to be sensitive to it, right? And as we are allowing, if you are that type of company and business that can allow it, that can permit it, understand that you as the employer, you generally can permit remote work on any schedule that you deem appropriate for employees based on certain location, certain department, position, or any other legitimate business reason. I mean, we need to ensure that there's no unlawful disparate treatment or disparate impact that's created. But typically, generally speaking, because facts matter, facts will change the analysis, right? You insert new facts, in certain facts, it will change the legal analysis quickly. But generally speaking, if I have a department or a specific position or group of positions, specific geographic area, that the work can be done, the quality and the quantity can be maintained through a remote work site, remote work for these workers or specific workers, that's generally okay. If that's a hybrid schedule or a full-time schedule, or temporary or indefinite. Now, this will likely change over time, and your needs and what you can allow today might change next month or next week or next year, and you can change the rules. You have the ability to change the rules in real time, as long as it's rooted in the legitimate business reason, a legitimate business reason. And again, you're not creating some sort of unequal, disparate, illegal, unlawful treatment. The other thing, and this is really a Kelly issue, is this remote work, because I know you've been dealing with this, Kelly, for a while, with related to income tax issues and unemployment issues. I don't know if you had anything else to add on that.
Yeah, it's important. I mean, this comes into play particularly when you have employees who are working remotely in another state. We see a lot of requests for that, and employers need to be aware that that will often trigger income tax implications and unemployment insurance implications in the state in which the employee is working. The specifics depend upon the state generally, but in most situations, say you have an employee, you're headquartered in Illinois, your employee wants to go to California for 6 months and work there. You will likely have an obligation to withhold California state income taxes and remit those to the state of California. So what that means is you will, in that situation, you would need to register with that state's Department of Revenue or whomever the income tax body is. And the same thing for unemployment insurance. So you may have, depending on the state law and where the employee is generally working. So if they're working remote, it's going to be that state that you want to make sure that you're aware of what your obligations are there. We did get a question on this beforehand, and it included employees potentially working outside the country. And that opens a whole new can of worms, because in addition to tax implications, certain countries, and again, the law will vary depending on where the employee is actually physically working. You may have to register as a business entity. So when it often sounds like a simple question. Well, sure, you can go to, you have family in South America. You can go to South America for, 2 months and work. But that may have a whole lot of implications that you haven't thought about. And sometimes that depends on the length of the stay. So a 2-month stay, may not implicate a business registration requirement, but you hire somebody there for a long time. Again, depending on the country, you might have to actually register a business entity in addition to, foreign income tax implications and things like that. So lots of specific issues if you've got an employee wanting to work somewhere other than where you're typical, or you've typically had employees working previously.
Yeah, Kelly, thanks. We've had clients that have made, because of the tax implications, and you got to look at that state to state. You got to look at it, where are they in the world? Where's Waldo? Where's your employee? Where are they? Where are they operating from? And how long? What's the duration of time? If it's temporary, if it's a couple of weeks, it's a couple of weeks. Nobody's going to say anything about that. If it's maybe even a month, but you get into several weeks become months, or the last 18 months, somebody has been working somewhere else. That has some serious potential tax issues, and even unemployment issues. So, which is a quasi tax system. So we've had clients, Kelly, that have created now rules on remote work. You can work remotely, but you need to stay in the state where you have been.
Yeah, and one other consideration that I didn't add on the slide is that you could also implicate, the state's employment laws. that
Yeah.
you're not, you have somebody who wants to go to California for a while, you've got a whole new set of employment laws that you may be unfamiliar with, that you now need to be familiarizing yourself with and making sure that you're complying with. And that might not be something you want to undertake for, one employee who, wants to do something. I mean, you may, but you just need to make sure that you're on top of it.
Yeah. And let's see, I don't know why this is, hold on. Why is this, it's like it's off. I don't know why I can't get that off my screen. I apologize. All right. So the next slide is signing, retention, referral, and perfect attendance bonuses. There's a lot of meat to this. To be effective, I mean, this can be effective, but you have to understand that this is riddled with potential wage and hour traps, primarily involving overtime calculations for hourly or non-exempt employees and wage payment obligations. So let me go through a few of these slides, and I think it will start making some sense. So if a bonus, as we all know, that if a bonus is really a gift, then it does not need to be included in the regular rate of pay, and no additional overtime calculation is necessary. Right? This goes back to the overtime rule: is if somebody works over 40 hours in a work week, or if you're in California, over 8 hours in a day, if there's, whatever overtime rules apply, the overtime premium of time and a half, the regular rate of pay, is not necessarily the hourly rate, the naked bare bone hourly rate. Employers have to also calculate into the formula all compensation that employee earned in that given period of time where overtime was worked. So if a bonus is a gift, you don't have to worry about that. It's just a gift. Oftentimes the bonuses, and it could be a signing bonus, it could be a retention bonus, it could be a referral bonus, it could be a perfect attendance bonus, it could be all types of bonuses that you're creatively trying to come up with, right? Because you want to recruit employees and you want to retain employees. So oftentimes these bonuses have strings attached. The string could be, I'll give you X, I'll give it to you, but you have to stay around for a period of time. That change, that's not a gift. There's strings attached to it. And if there's any strings attached to the bonus, you're triggering this overtime calculation change, modification. It's going to impact the regular rate. Now, one way to get around that is if the bonus is based on a percentage of total earnings earned in it, then you don't trigger the regular rate, because regular rate calculus isn't triggered, because the overtime is baked into this calculus, because the bonus is based on a percentage, not a dollar amount, a percentage of the total earnings, which would include any overtime earnings in a specific period. So this point, what I'm emphasizing here, is really, really important. Many employers stub their toes because they don't understand this little hiccup in wage and hour law. So the way I look at it is, if there's a bonus and there's any strings attached to the bonus, that is likely going to impact overtime calculations and the overtime premium for the non-exempt worker who works overtime in periods where the bonus is deemed to be earned. Now, so any condition that's placed on the payout, a condition could be you must be employed at the time the payment is made. You have to perform some sort of function or take certain action or refrain from certain permissible conduct, or it's tied to a certain length of service, longevity bonuses. I'll give you the bonus, but I'm only going to pay it if you're employed at the end of the year. if it's not based on a percentage, that's going to impact the overtime calculus, but it's also going to likely be deemed a bonus that is not subject to any sort of clawback or forfeiture. So particularly in states like Illinois, California, if it's tied, if these bonuses are tied to some sort of longevity, some states will require a pro rata payout, regardless of what's in an offer letter or a contract or a policy or any sort of employer plan, memo, communication, because the rationale is that the payment is deemed earned in part. Now, some of these jurisdictions, the same jurisdiction, will permit forfeiture if the employee voluntarily resigns or is terminated for good cause or gross misconduct. And remember, a clawback provision does not necessarily change that. You could pay it up front, but then you reserve the right to deduct later if they don't stay on for a certain amount of time. That's the same thing as a forfeiture. So just remember that you've got to look at these bonuses and your communications in your plans with an eye on the state that the worker is primarily engaged in, where they're primarily engaged in. Quick note on referral bonuses, and this is actually tied to a Biden administration, Department of Labor. No, it wasn't Biden. I think it was Trump administration. I believe it was a Trump administration DOL memo. But regardless, I think that this would play in the same sandbox as any administration, whether it was the Obama administration or the Biden administration. I think they would have the same take on this, because this memorandum really kind of summarizes what has always been the case on referral bonuses, and really a lot of bonuses tied to the difference between tied to longevity or deemed as a pure gift with no strings attached. But a quick note on referral bonuses. This may be deemed a gift, because we give, a lot of employers are going towards a referral bonus. If you refer somebody, then you'll get, let's say $1,000. You don't have it can be deemed a pure gift, not included in the regular rate of pay for overtime purposes. When it is, all three have to be there. It has to be voluntary. Recruiting is not part of the employee's regular job duties. It involves minimal time and activity, and the recruiting activity is typically done after hours or in social settings. But if the bonus is tied to longevity, requiring the referral or the referring employee to be employed in the future at a certain date, then that's going to trigger overtime regular rate of pay issues. If we're not going to pay it out until 6 months down the road or a year down the road, that would also likely trigger that some pro rata portion needs to be paid out in some jurisdictions. And again, in some jurisdictions where there's a pro rata, anti-clawback, anti-forfeiture law in place, there might be an exception for voluntary resignation or a termination for quote unquote for cause. So this gets the point here is this can get complicated and create some legal traps. That's not to say you shouldn't do it. You can work through those fairly easily, but you have to identify those traps and potential traps and pitfalls along the way, because you don't want to have wage and hour exposure that you're oblivious to when you're implementing these bonus programs. So let's talk about gifts and prize drawings and other incentives. Real quick, The prize drawing, that is a type of gift. And I'm seeing employers, Kelly, we're seeing employers create a drawing. If you're around at the end of the year, we're going to draw you. You're going to be in the hat with 1,000 other people, and you can earn $10,000.
Yeah, I'm seeing it too.
I don't know if they're working. I haven't checked in. We'll see. We'll see at the end of the year and see how effective they were. But a lot of employers are going to, you become employed at any time in 2021, and you have at least 30 working, I'm coming up with an example here. You've got at least 30 working days under your belt. We're going to put your name in this lotto. It's a gift. I don't think this impacts overtime. I don't think this is anything earned. It's a gift because the lotto would be the drawing would be in the future. It's a pure gift. There's really no strings attached. You just got to be on the payroll at some point during the year. But I think, are we triggering issues involving disparate treatment or disparate impact? We certainly are triggering income tax issues. So who's involved in the lotto? Who's eligible for this drawing, this prize drawing, and who's not? That could create some, potential discrimination issues if you're singling out certain individuals by a protected characteristic, intentionally or not. And of course, this would be income tax, right, Kelly?
Yeah.
It's money.
Yeah. Absolutely, yeah. And it's important to keep in mind even things like gift cards. Gift cards, the IRS considers gift cards to be a form of cash compensation generally. And so those would be taxable if you're doing something separate from a lottery, but you're trying to just find some other, smaller types of gifts. You just need to talk to your accountant or your attorneys and make sure you know what's going to be taxable to the employees and what's not, and part of your planning.
Yeah. So, Kelly, when I like going to, if I'm going to spend an hour listening to somebody, or, if I'm going to go to a seminar, I like to get free stuff.
Yeah.
And so what we've done here, folks, is we've created a sample. It's a sample, it's just a sample. It's not a template. It's a sample. It's to give you something to kind of get your mind moving. If you're going to implement pay enhancements, if you're going to implement bonuses, potential special prizes, this is, some sample communications to your employee. And also we've included some sample internal HR policies to help protect you from a legal standpoint. I'm not going to go through I'm not going to read these slides, but I want to draw your attention to that all of the elements and considerations that go in to implementing bonuses and pay enhancements or special prizes. Defining who is eligible, defining and excluding certain employees, right? If you're excluding certain employees based on department or position, again, as long as you're not triggering disparate treatment or disparate impact, there shouldn't be an issue. If you are going to implement something, identifying who's eligible and who is not eligible is really important. And then creating, going through, and this example is, we've got an hourly rate increase that we're going to implement as of August 10th, 2021. And this is going to go into effect on September 1st, again, sometime in the future. This is, we also, in this sample, we're identifying perfect attendance bonuses. And if we're going to have a perfect attendance, we probably need to define what perfect attendance means and what it doesn't mean. And so we're not stubbing our toe under a disability or creating liabilities related to the perfect time, perfect attendance, and creating clawbacks or problems for people with medical conditions or medical reasons, or mandated, we've got to honor mandated leaves, retention bonuses. Again, if it's tied to longevity, that could impact overtime, and it could impact the payout in certain jurisdictions and anti-clawback, anti-forfeiture jurisdictions. This sample goes with the percentage because we don't want to trigger overtime if we don't have to. And then it goes into the drawing. That communication is important, but also the HR policy. And you can see in the red, these terms and conditions are all part of a policy that HR keeps and maintains. And seek HR or go to the website, the intranet, for more information. And then that HR policy will then memorialize what we've communicated, but has more meat on the bones from a legal standpoint. What is the weekly perfect attendance bonus? How is it calculated? Putting in something, none of the following categories of absences shall count against the employee for perfect attendance purposes. And, those exceptions make sense. Going through the calculus, showing the employees how this might impact their pay. Not only showing the employees, but showing management, showing payroll, showing, business leaders within an organization how this works. So everybody is on the same page. And then the same thing with the retention bonus, what it means, how you're eligible, what about a payout upon termination, other payroll considerations. So there's some, a lot of meat that goes on these bones when you're coming up with these bonuses, these bonus programs, and other incentives tied to recruiting and retaining your employees. Another sample are the work rules. If you're going to do any sort of year-end drawing or a lotto or a prize drawing, most states, most jurisdictions have anti-gambling laws, and you want to make sure you're compliant with the anti-gambling laws of a certain jurisdiction. This sample, fairly universal, but again, I would vet this with competent legal counsel before you implement. But we don't want you to stub your toes. So this is your rules. You need to have if you're going to do a drawing of sorts, you need to have certain rules in place, official rules in place, to not violate applicable anti-gambling statutes. And this goes through, the entry, the drawing, the prizes, the eligibility, how it impacts wages, tax, other terms and conditions. This is all the legalese, right? You would expect legalese if there was a lotto or a drawing. The same thing would apply to an employer implementing the same thing. Limitation of liability and other miscellaneous provisions that you would have in an internal policy to protect your bottom line. So Kelly, I'm going to turn it over to you now. This is, really your topic on deferred comp as the ERISA executive comp benefits lawyer.
Sure, absolutely. So one option for employees that this has been around for a while, but it's something to consider in these times as well, in that it can help with retention, would be some type of deferred compensation arrangement. These can be individual agreements, or you can have a plan, kind of depending on who this is going to apply to. It's a type of benefit that you can generally, within limits, which I'll talk about in a few minutes, you can generally design in whatever way is going to work for you. And there's a variety of ways to do it, but what I'm going to talk about in this context is using deferred compensation similar to our retention bonus, but it might be something that covers multiple years, multiple tax years. And the IRS considers deferred compensation to be any compensation that an employee has a contractual right to in one year, but is paid in the next, with a few exceptions. There's a short-term deferral exception, which allows you to pay bonuses within a certain amount of time after the end of the year and things like that. But generally, if somebody enters into a contract for a certain type of compensation, and the only condition is that they are still there, and it crosses multiple tax years, falls under this deferred compensation bucket. An example might be maybe for an executive or management where you're wanting to have a substantial impact, maybe the executive is eligible to receive $20,000 if they're still employed December 31st, 2024. So that would be a classic kind of deferred compensation bonus. These are subject to really strict IRS rules. And why is that? It's because they want their money, right? So if you're going to not pay something until a future tax year, it needs to comply with a variety of conditions. And these were all put in after Enron. If those of you that have been around long enough to remember that, where there was some perceived abuses about deferred compensation or executive compensation. So if you're going to do a deferred compensation or a multi-year retention bonus type of arrangement, it's got to be in writing. So it can be an individual agreement or a plan document, depending on what you're doing. And it has to specify how and when that it's going to be paid, what the rules are around earning it, meaning if the employee needs to be there December 31st, 2024. And just like Jeff said, with regular shorter retention bonuses, you have to be mindful of state law. So if generally if an employee voluntarily just leaves, you're not stuck paying a prorated bonus, but you got to be, the state laws are changing all the time and you need to be mindful of that. So these types of arrangements where I see folks trip up is that once you have the payment terms defined in any type of deferred compensation, they cannot be changed. So those are very strict IRS rules. So you need to say, this is going to be paid. If you're here till December 31st, 2024, we're going to pay this in 2 installments. We're going to pay it, January 15th of 2025, and then the other half, January 15th of 2026. And if it says that, you cannot change it. So there was an example is there's an IRS ruling on a company that their plan actually had the discretion. It said, but if we want to, we can pay it all in a lump sum. And that violates these. It's what's called Section 409A rules. So if you're thinking about doing something like this, you want to, again, consult with competent counsel who can help you set something up, because the penalties for not complying with these tax rules regarding deferred compensation are generally immediate taxation. So something would be taxable to the employee the first year they're eligible, when they don't even get it paid till multiple years out, and there can be a 20% penalty on the employee. So that's not going to help with your retention or your recruiting if that gets around. Okay, I'm on to the next slide, Jeff. Thanks. So another potential thing to think about is flexible schedules. So this dovetails nicely on kind of the remote work that we've talked about. So flexible schedules can include a variety of remote or in-office work, or it can be all of one or the other. This can help with employees that have additional obligations outside of the workplace that everybody's facing during the pandemic. And if you're going to do this, the best way to avoid running afoul of potential problems is you need to implement a formal policy with clear expectations. It needs to be in writing, and generally that might be a general policy, and then the terms of anything you agree with an employee should be documented somehow, whether that's captured via email or something more formal. One potential option that works well for some employers, depends again on your business, is setting something like core hours. So maybe you want to say everybody works in the office from 10 to 2, but outside those hours, you can come earlier or later. I would advise having employees determine that up front, so you know what their schedule is. That's easier to manage, but there can be some flexibility there. 4 10-hour days instead of 4 8-hour days, things like that. But in any policy that you have, you want to be very clear that these arrangements can be changed or changed or terminated if by the employer. There's a variety of reasons for that. Performance is lacking, business conditions change, job requirements change. Sometimes things just change, and you can and have that discretion to terminate an arrangement if it's not working. Monitor these closely. So you want to make sure that it's working for you, the employer, and the employee. So make sure they're complying with what they've agreed with. And it's important to be mindful of local or state mandates regarding scheduling restrictions. We're seeing some more development in this area. One example is the Chicago Fair Workweek Ordinance, which has a variety of requirements, but one being employees need 10-day advance notice of their schedule and things like that. Is there anything else you want to say on that, Jeff?
No, I think you covered it nicely. And I would just say, be mindful of treating similarly situated employees similarly under similar circumstances. That's key. Yeah.
Yeah, absolutely. Make sure you're not falling into any disparate impact or disparate treatment issues.
Yeah.
So restrictive covenants. So there's a couple things to be mindful of here. And by restrictive covenants, we're talking about non-disclosure agreements, non-solicitation clauses that can be non-solicitation of customers and or employees, and non-compete agreements. So we're seeing a couple different implications. If you're looking to retain your employees, one potential option might be to consider some of these agreements, and might make it harder for employees to leave. Something to think about. And Jeff, do you want to talk about some of the other considerations?
Yeah, sure. I mean, I do a lot of this work, and I think that, you're seeing it on both sides. You employers want to protect their turf. They want to protect the relationships that they created, that they're introducing new hires to, but at the same time, a potential candidate, especially in the area of sales or key management personnel, they don't necessarily want to be tied to a non-compete. And of course, you've got the Biden administration and efforts to try and try to void non-competes. We're starting to see that on certain state levels, voiding non-competes at times of pandemics and making them more, just regulating them more and more and more. But I think the takeaway here, Kelly, and what I want to emphasize to everyone is, if you're thinking about eliminating certain provisions because you need to bring somebody in, that's fine. You can try and modify, but understand that if you're completely eliminating the non-compete or restriction, that will be used against you in future litigation, that you're not being consistent in your non-compete, because I'm talking about the traditional non-compete, because and it will be used to argue that you don't have a legitimate protectable interest here. So being mindful that what you eliminate from these covenants can be used against you by a defense in future litigation. And on the other side of this is understand that if you go after someone else's employee, understand that we're being aggressive in trying to go after and for lack of a better word, pirate other employers, other competitors' employees. That has legal ramifications. So you need to be mindful, even if there's no non-compete, you need to be mindful that there still could be non-solicitation clauses and non-disclosure agreements. So from a confidential information and trade secret perspective. So a lot to consider with restricted covenants. Kelly, I would not throw them to the side. I would continue to use them. They make sense, but it's probably time for everyone to reevaluate what they have in place.
Yeah, absolutely. Right. So I've been getting this question a lot. In this tight labor market, you find somebody, what do? You find somebody, you think they're going to be great, but they're getting screened out with your traditional or current background check policy or drug testing policy. One thing employers may want to consider is whether it makes sense to relax those a little bit. Do you suspend or eliminate some of these the policies that you have regarding screening people out, whether that be based on criminal history, credit history, education requirements, references, social media, things like that. In this labor market, there may be things that would typically screen somebody out that you may want to take a second look at. A couple of things to be mindful of if you're going to think about doing that is you want to make sure that you have a choice. There are mandates for certain occupations or industries, things like banks, you have to have certain background checks, and certain bank employees, certain criminal activities will screen them out. Same with healthcare workers, certain workers, things like that. So you certainly don't want to not comply with your responsibilities for certain positions and industries, but there's nothing preventing you from temporarily modifying or suspending the requirements that you have taken on yourself. So I would still advise that you do these types of checks if you've been doing them because you want to know. But maybe what you're doing is you have somebody who has some criminal history that maybe you have a serial killer or somebody that has some type of criminal history, and it's important to know that, because if you're going to hire them, you're going to want to, make sure that you've got them in a position where you're going to want to do what you can to lower the risk, right? So you're not going to want to have them going out into people's homes, but you've got positions where, they're in the office, there's lots of people around, other types of things. So, or somebody that has had a financial crime in the past that might have screened them out before. You're going to, monitor more closely, and you're going to make sure they're in a position where they don't have access to cash, things like that. So there's nothing preventing you from taking a second look at these in this environment.
Yeah, and Kelly, I would advise a client that if they want to put certain parameters and expectations,
Okay.
like we're going to check in. We're checking in, constantly, regularly, but we're going to evaluate this after 30 days to see if we want to continue it. Or if you commit any infraction, we're going to have a different, and it's got to be tied to, I'll use conviction, a criminal conviction. There's got to be something where that it relates to the job, right? To keep all of this legitimate. But I wouldn't hesitate to create sort of rules of engagement unique, because I would not otherwise hire you, but I am. And if I am, it's going to be on these conditions that you have to follow. And it is what it is. I'm not singling you out, but you happen to be a serial killer, and I got to be a little bit more cautious.
Yeah, absolutely. That's a great idea. Yeah, and so the same thing, you have the same considerations with your drug and alcohol tests and screening. So is this something that you want to relax? And that doesn't mean throw all caution to the wind and eliminate your policy, but maybe you're going to be more likely to implement a last chance agreement now than you would have before. So if somebody does test positive for it's illegal drugs, or maybe being under the influence of something like alcohol or cannabis while they're on the job, maybe you're going to give them you're not going to terminate them for one offense, but you're going to enter into a last chance agreement that requires more closely monitoring, more tests, and give them an additional chance. Or maybe you're going to suspend your cannabis, your rule that you're rescinding offers if somebody tests positive for cannabis in the pre-employment phase. Maybe you're gonna relax that for now. But again, things to think about. You have to be particularly mindful of safety sensitive positions. So if you have a driver, somebody who's driving a vehicle or driving a forklift, and they've tested positive in violation of your policy, that might not be a position that you want to give a last chance agreement to. But in other situations, as long as you're being mindful of the safety sensitive positions and being aware of any disparate impact considerations, this can be something to consider.
Yeah, I've seen clients, Kelly, go with a temporary modification of our pre-employment drug screening, or a temporary, and again, the key word there is temporary. We can always go back to a more hardened less discretionary policy later on. But in light of the labor market and the current conditions, we have to think differently.
Yeah, absolutely.
So if you do modify, it's not forever, right? I mean, I guess that's the point.
Yeah, and I think that's important for employers to know, is that you can go back. That making this change doesn't mean that you're stuck with it. Okay. And I'm going to try to go a little faster on the next couple slides so we can wrap up here. So what else can you do to kind of keep your employees happy, potentially bring new employees in? If you've got all the kind of the standard, you know, your compensation's good, you've got the standard benefits, what are other things? So you can consider what's called voluntary benefits. So these are programs that are often offered like through an employer, but employees will generally pay for the full cost through payroll deferral or payroll deduction, I should say. So the benefit to the employee is that it's easy, right? And they will often get group rates that they wouldn't be able to get alone. And there's all sorts of examples of voluntary benefits, but popular ones are critical illness insurance, accident insurance, hospital indemnity insurance. That's something that might just pay a flat rate, you know, $100 a day if you're hospitalized. It's for other expenses. ID theft is a very popular one, ID theft protection, financial counseling, legal services, pet insurance, you know, access to telemedicine. There are programs that are separate from your typical health insurance, and other types of, you know, long-term care is popular, and then additional life or disability insurance that's individual to the employees. The thing to be aware of here is that generally for these types of benefits, you don't want them to fall under ERISA, the Employee Retirement Income Security Act. It has a lot of fairly onerous reporting and disclosure and other requirements. So to keep voluntary benefits out from the umbrella of ERISA, they have to be employee paid. Employer involvement has to be limited to things like just making it available, publicizing it, collecting and remitting premiums, things like that. And the employer can't receive like a kickback for, or even payment for administering the premiums. If any of those things are not met, then it becomes subject to ERISA, and you can still offer it that way, but then you have a lot more compliance requirements in that case. Other benefit ideas, maybe consider benefits for part-time employees. If you have, if a part-time employee workforce is something that that you use and is helpful to you at this point, you can consider including them in some or all of the benefits for your full-time employees. It doesn't have to be all. There are some that make sense and that may be easier than others. Prorated vacation and paid holidays tends to be really easy to give to part-time employees. And another thing to think about is there's been a change to the law that's going to kick in 2024 that requires employers with 401k plans to include part-time employees in the plan, or they're eligible for the plan if they work 500 or more hours in a year for 3 consecutive years. So and maybe if you're going to have to do that anyway in a few years, you know, maybe that's something to consider adopting earlier. So one potential consideration. Some other possible benefits. This doesn't work in every industry or with every employee group, but unlimited PTO. We see some clients do that. That works well when when output can be closely managed. You want to make sure that employees are still getting the job done in that scenario. You need to be very careful about language of a policy and communication, so that you can limit your exposure and your payout upon termination for employees in that scenario, because as you likely know, many states require payment of accrued and unused PTO at termination. So if you have unlimited PTO, you want to make sure that you're not creating a significant liability there for yourself. But it can be done. You just need to have the policy drafted closely. Other benefits to consider, you know, with the pandemic going into what our second year here, employees are expressing interest in employee well-being benefits, family-focused benefits. So things you can do to support your employees in this time, whether that's more mental health benefits, maybe that's an EAP if you didn't have an EAP before, or sometimes referral types of services, anything that can help employees with some of their burdens outside of the office. So it's you know, a daycare referral service. You know, most employers aren't able to offer, say, on-site childcare, but maybe you contract with a service that does backup childcare, or maybe you give some reimbursed for childcare expenses, or even a childcare referral service can be helpful. as well as financial well-being, education, things like that. What do you think about when you're attracting new employees? You've got to figure out how to do it virtually now. Be sure and train your managers so that they're consistent messaging, doing things appropriately. Consider creative pay, like phased-in salary increases. Make sure you're looking for potential, disparate impact or disparate treatment issues. You need to treat people with similar circumstances similarly. You don't want to have any equal pay issues either. And then watch for valid restrictive covenants that your incoming employees might have, so that you don't run afoul of those. And there are things you may be able to do to creatively diminish some of those risks.
Yeah, Kelly, at a minimum, when we hire new employees with restrictive covenant, non-disclosure, particularly in sales or key management, I have them, I want to insist on them at putting it in writing that they're not taking, they're not going to use any information that they got from their prior employer. They're not going to share it. They're not going to use it, and they're going to honor any valid restricted covenant.
Yeah, absolutely. This slide, I'm not going to go through all of it. These are a handful of ideas that may or may not work for your business, but we wanted to be creative here and share with you some things that we've been seeing employers trying to do to enhance employee engagement, really, and then make employees happy, make them feel good when they come to work, and then potentially that may, factor in when they're getting that call from recruiters. So there are things like, vacation bonuses, and give a bonus for employees to spend on their vacation when they take a vacation. Now, all the other things we talked about bonuses apply. On-site massages, bring in a masseuse, make sure it's a professional. You don't want to have them giving each other massages. And you don't want to have liability for some, for a hack, but, you can do head and neck massages in the office without any trouble. Enhance your work environment. Consider tuition assistance. Student loan forgiveness is a big deal as well. And recreational memberships, there's things like online subscriptions now that really didn't exist. I mean, I'm sure they existed, but they weren't really, when employees talked about, gym memberships or reimbursing things like that. But now there's online subscriptions and those types of things that employers can provide employees even more easily than, pre-pandemic. Many of these things, if you have employees that are under a CBA, you will likely need to bargain with the union, because most of these types of benefits or pay or other things are going to trigger mandatory bargaining obligations. So if it's seen as a benefit to the employee, likely not a problem, but you have to follow the rules in the CBA and make sure that you are consulting with the union. Do you have anything to add on that, Jeff?
Nope, you got it perfect.
All right. And then this may be our last slide, I think, where refusal to work issues and unemployment concerns. So many employers are facing this. So earlier this year, the Department of Labor announced that employees were eligible for those enhanced federally funded employment benefits for additional reasons related to COVID. And so the one that I see the most issues with is employees who refuse to return to work that is unsafe or accept an offer of new work that is unsafe. Things like experiencing a reduction of hours or temporary permanent layoff is fairly standard. And then there's certain categories of individuals that provide services to educational institutions. But allowing employees that are choosing to leave work or refuse an offer of work for unsafe reasons has the potential to, have employees, I don't want to say necessarily take advantage of, but employees may see that as an opportunity, or former employees. So what do you do? Employees get this benefit if they attest that they refuse to return to work or left work because their employer or their work site is not in compliance with local, state, or national health and safety standards directly related to COVID-19. So it includes things like face masks, physical distancing, PPE, etc. So what do you do to counteract that? You got to follow the local, state, national health and safety standards directly related to COVID-19. So you certainly need to follow any local or state mandates that are out there, but also you want to make sure that your policies and procedures are in line with the most up-to-date guidance from the CDC, in addition to federal, state, and local agencies. And I would add, and Jeff, you can let me know if you agree with this, I would add, you want to be in line with the CDC guidance, even if your state has not enacted, a requirement.
Oh, yeah. I agree.
Absolutely.
Agreed.
So, yeah. And then you need to communicate it. Make sure employees know what the requirements are. Make sure that you're taking steps to take care of their health and safety, improve health security. Communicate that you're monitoring the CDC and public health guidance, and that you're ready to implement further changes as the guidance changes. Because as we all know by now, it's continually changing, changes every day. It's going to continue to change throughout the fall, I'm sure. And then, give employees an opportunity to express questions, concerns, et cetera, to management without fear of, adverse consequences or retaliation, and communicate what that avenue is, and then employees are free to do that.
Yeah, I think the bottom line is we're just trying to avoid having people leave or not return or refuse employment, and trying to give them and explain that there's no valid reason for them to do that if they are concerned with safety or health. And that's the bottom line, I think, Kelly, with this.
Yeah, absolutely.
So that's the material. Kelly, I think the big three that come to mind to me, and we'll conclude this, is the employers doing pay enhancements, implementing pay enhancements across the board. But again, look at it by position, by position, because not everybody is created equally. They're doing different jobs and different work, or geographically, right? What we can do in Southern Illinois might be different than what we need to do in Chicago. And then the other thing is retention, like perfect attendance bonuses. If you show up each workday that you're scheduled each week, we'll add a little money. And again, that can create overtime issues. That can create, no forfeiture, no callback issues. But it is what it is. And the other big one is similar to perfect attendance, is some sort of retention, some sort of prize drawing, or just some sort of retention bonus.
If those things are going to have the biggest impact. I mean, if you're really struggling to, retain employees, having a dog-friendly days is not going to do it. If that might be fun, but those things.
It's the money.
Are going to have absolutely,
Yeah. All right. Well, we don't have time to address these questions, but we will address these questions immediately. And so please look for your email. Please look at your spam file. You will get something from our marketing team, our excellent marketing team. And Kelly, thanks. If you have any words of wisdom or parting words of wisdom, we'll conclude.
No.
Okay.
Sounds good. Thank you, everybody.